My lord, so last submission, my lord. Yes. Just one word, my lord. Section 12, Schedule 5 and 7, in my opinion, should be kept away while deciding this matter, my lord. This is a matter which is going to decide a system which is going to test the arbitration clause and its validity. My lord, that is a post-appointment system. That post-appointment system prescribes 19 items in the Schedule 9 and 34 items in Schedule 5. They are only an opportunity for the parties to know about their personal connections. So that is a different issue that should not be kept in mind while deciding this. Here, my lords are going to decide the validity of a clause or a system which will ensure neutral arbitration, Lord.
Thank you so much, Mr. Ravishankar. Mr. Rohan Kalwa.
My lords, I'm going to address my lords firstly on a proposition which has not been discussed, which is the skewed incentive which arises in unilateral appointment procedures. My lords, on two stakeholders. One is the appointing authority.
So you're saying skewed incentive?
My lords, in cases where there are unilaterally appointed panels or unilaterally proposed panels. My lords, firstly, qua the appointing authority, anyone who is going to be rendering a verdict in their favor, there is a perverse incentive in economics which is called to reappoint that person in the panel. And my lords, it's a known thing that panels are reviewed periodically and thereafter curated. My lords, the second skewed incentive is of the arbitrator in this case, who, my lords, has an incentive to remain on this panel. So, my lords, what would happen is that
what is the first skewed incentive?
My lords, of the appointing authority, that if I'm an arbitrator and I give a judgment in favor, let's say, of the appointing authority, I'll be reappointed.
And there is no provision in the Act which bars reappointment in more than one arbitration.
Absolutely, my lords. My lords, there may be cooling
beyond 3 times.
Beyond 3.
And
Schedule 5.
My lords, here, so
Schedule 5 item. Schedule 5 is it?
Schedule 5.
Previous services. Item 20.
20. Yes, 20.
Arbitrator has within the past 3 years served as been appointed as an arbitrator on 2 or more occasions by one of the parties or an affiliate of one of the parties.
My lords, however, this is on the point of impartiality at the stage where I'm questioning the appointment. I'm saying that in a year...
So in 3 years, you can't accept more than 2 arbitrations from one party.
My lords, however, if I'm to be...
Therefore, it's clear in a case where you come across a situation where a person in the panel has already been appointed twice, you would say that you can't appoint him at all.
My lords, firstly, these aren't disclosed.
Different from what's being argued.
What one more thing was to say after?
My lords, I will only pick a person even after the scope of 3 years who has decided in my favor, and within those 3 years I can repeatedly appoint up to twice for someone who's decided in my favor. This is qua the appointing authority, let's call them railways. Qua the arbitrator also, my lords, the perverse incentive is to remain on this panel. And my lords, I may be on several panels. I may duplicate my appointment, and therefore this perverse incentive in fact is recognized in a judgment, my lords. It's by the name of Hooters of America versus Phillips. It's at page 3585 of volume 3, my lords.
Hooters was actually referred to in that judgment which was cited by Mr.
My lords, Mr. Banerjee also referred to it. There's just a sentence there which I want to refer to, my lords. So here also there was a panel.
So what they have held, they said that such person is ineligible to be appointed.
My lords, and there's a very interesting sentence, my lords, just following from what my lord said.
Read.
My lords, I'm at page 3589, relevant. The appointment procedure is the employee and Hooters each select an arbitrator, and 2 arbitrators in turn select a third. Similar to core, similar to my case as well. My lords, the bottom of that paragraph, 4th line. Further, nothing in the rules restricts Hooters from punishing arbitrators who rule against the company by removing them from the list. Given the unrestricted control that one party, Hooters, has over the panel, the selection of an impartial decision maker would be a surprising result. Well, this is one incentive I wanted to.
Interesting. So within a period of 3 years also, you appoint an arbitrator on a second occasion.
Absolutely.
And once, even after the period of 3 years, the bar of 3 years has expired, you'll have an eye on who held in your favor in a previous arbitration. That's your point.
3 years maybe a cooling off period, but after that, as my lords are saying, I'm aware who is decided in my favor.
So therefore, in the new proposed amendment, exactly this is what it is. The proposed amendment says that we will now have, instead of a prohibition, a cooling off period.
Apologies, my lord, I couldn't.
There's a cooling off period suggested by
My
the new
lord.
panel.
And my lord, the second point I want to raise is regarding the legislative infraction. What is exactly prohibited under this act? My lords, I want to read a sentence at the cost of repetition in TRF and one sentence in Perkins. If my lords may have page 1033 of TRF.
What you want was the submission?
My lords, the submission is that there is a implicit legislative bar arising out of the fact that an individual who has an interest in the outcome of a dispute cannot be made the appointing authority.
That Mr. Paul argued.
My lords, just a sentence to show where is this coming from legislatively. What is the statutory bar here, which these two decisions in my respectful submissions have addressed already. My lords, at para 57, 1032 bottom, in such a context, the fulcrum of the controversy would be, can an ineligible arbitrator like the MD nominate an arbitrator who may be otherwise eligible and a respectable person? As stated earlier, we are neither concerned with objectivity nor individual respectability. We are only concerned with the authority or the power of the managing director. By our analysis, we are obligated to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. And I'll end at the next sentence. The arbitrator becomes ineligible as per prescription contained in 12.5. Now, my lords, this is interpreted in Perkins and without apologies. My lords, this next sentence from Perkins is at 1274, my lords. I'm reading paragraph 16, where they interpret what is this. My lords, I'll just read that sentence. The ineligibility referred to therein was as a result of operation of law, in that a person having an interest in the dispute or in the outcome of a decision thereof must not only be ineligible to act as an arbitrator, but must also be eligible to appoint anyone else as an arbitrator. My lords, at the foot of this paragraph, that has to be taken as the essence of the amendments brought by the Arbitration and Conciliation Amendment Act 2015. Independence, my lord said, is a complete virtue. It can't be negated at margins. So, my lords, if independence has to be seen as an absolute virtue, this amendment introduced independence and impartiality. What my lords have said in Perkins is that the essence of this amendment is that an interested party cannot adjudicate. If an interested party cannot adjudicate because they have an interest in the outcome, they cannot nominate. Now, whether I nominate 1, 2, or 100 is immaterial.
Thank you. Thank you, Mr.
My obliged, my lord.